How's it going, everybody? Craig here. So I hope that intro worked. It's a little buggy on my end. You have to let me know for anyone that was here for the beginning if the intro worked or not. So this is I'm live streaming today. Live streaming to my YouTube channel and to my Facebook page. And I didn't announce this or anything. It's just something that I'm planning to do starting starting today. I'm going to probably live stream every day unless I have another conflict. I'm going to live stream from about 4:30 p.m. Central Time until about 5 o'clock p.m. or longer if there's people here that have questions. I'm just going to answer questions. I do have some stuff that I'm going to talk about if people are interested in that. You should be able to comment. So you should be able to go on to YouTube and comment if you want. I will see it in a live chat feed, or you can also check me out on my Facebook page. Attorney Craig Stager is my Facebook page. Either one of those, you should be able to see the stream and comment. And if you have any questions that you want to ask, it can be legal or non-legal related. Doesn't really matter to me. I just may not have an answer for you if it's outside my normal area of expertise. So anyway, this is something I'm going to do for a while and see if people find it helpful and useful. One of the reasons that I'm doing this is I get a lot of the same questions over and over again as an attorney. Sometimes it can help people, sometimes it can't help people. And it would be helpful for me to be able to point people to videos that have sort of answers to some of the common questions, might save people a phone call or an appointment with an attorney, might help answer a lot of the questions that you have before you talk to me or talk to another lawyer, things like that. And also, if you just want a chance to chat or ask questions to an attorney, no charge. Here's your chance. Now, keep in mind, as the little disclaimer across the bottom says, this is for informational purposes only. It's not legal advice. And chatting with me does not constitute an attorney-client relationship, which means I'm not your lawyer. And you should always consult with a lawyer in the jurisdiction you practice in if you need any actual legal advice. But I'm happy to answer general questions for informational purposes as best I can. And like I said, I'm going to do this every day, Monday through Friday, starting around 4:30 p.m. Central Time, if anyone is interested. So if you missed it today, just show up tomorrow or the day after. Feel free to leave a question. If you have questions, if you watch the replay after the fact and you have questions about something I said, you can just leave a comment. I'm pretty good about checking the comments, and I'll try to bring them up on the next live stream. If you'd actually like to get on camera or talk and have a conversation with me about a particular thing that you're wondering about, we can do that. The only thing I need to do for that is to get some basic information to make sure that you're not calling about an existing case and that I have either I or my firm has a conflict of interest with you or the other side. But best way is just to go to the link tree. That's the best way to get a hold of me. That's always in the description below. Feel free to call or text. And I think I have a number. Let me see here if I can get that up on the board for you guys. Yeah, that's a Google Voice number. You can call or text that. Best if you text it and leave a number or an email address that we can reach you at. Feel free to call or text that if you have any questions that you'd like answered on here, questions that you just like answered in general. Feel free to send us a message there or go to the link tree if you'd like to get on my calendar and actually schedule a call with me. So anyway, wanted to get that kind of out of the way to start with. If you happen to come across the stream, and let me know if you hear me okay or don't hear me okay. It should be coming through. I do quite a bit of live streaming on some other channels, so it seems like it should be working okay. So anyway, with that in mind, so what I wanted to talk about today, just because I get a lot of calls on medical malpractice, and I don't take many medical malpractice cases, and actually most attorneys don't. But I get a lot of calls about medical malpractice because I'm one of the few lawyers that handles those cases. And so I want to try and answer some questions or common myths that people hear about medical malpractice. And this is something I'll be bringing up in other live streams in the future, no doubt. But I wanted to show you, and I'm even reluctant to share this, but I just had to talk about this. So my buddy Nick Rowley, who's a lawyer in Iowa, but I think he primarily practices in California, got a monster medical malpractice verdict, I think last week, just before Thanksgiving, down in New Mexico. I'm going to try and put that on the screen. And yeah, and let's make that the full screen. So sorry about the videos in there. So he got a $412 million, $412 million medical malpractice verdict. Now, that's just the verdict. It's got to stand up. Usually Nick's verdicts are so huge that they get appealed or challenged later, because he's just a tremendous medical malpractice attorney. But he got a I think that might be his biggest medical malpractice verdict. He always sends me his verdicts when he gets them. And there apparently was allegations of fraud and things like that. The guy had gone in for, I think, testosterone or hormone replacement, and this clinic down there talked him into some penile injections. And I think, so there's punitive and compensatory. I'd have to look up let me see if I can get it on Instagram here. I'm going to see if I can locate the verdict itself, because I'm curious how much was compensatory and how much was, So I'm on Instagram. I'm looking at his, that's a Tesla one. He got a huge Tesla verdict too. Let me see here. Yeah, here's so his verdict down in New Mexico. Let's see. So it looks like they got punitive damages of $375 million. So a huge chunk of that $412 million verdict was for punitive damages. I don't know the whole story, but that's just an enormous verdict. And then let's see, compensatory damages, which is still, compensatory damages is what most of us are going to recover in let's say, a personal injury or medical malpractice case. That's things like medical expenses, lost earnings, pain, suffering, and disability, past and future. So those are called non-economic damages. And that all totaled, looks like 37 million, $5,149. I'm not sure how they came up with that. Probably some medical expenses in there. 100% fault on the defendants. And he also looks like he won on a fraud claim, deceptive advertisement. I don't know the extent of the plaintiff's injuries in that case, but $412 million verdict, of which, what did I say, $375 million were for punitive damages. Now, I'm sharing this with you because, this made national news. This is ABC News here. Um, these verdicts are extremely, extremely rare. I can't even begin to tell you how rare this verdict is. And in fact, it actually goes against one of the things I'm going to talk about here in a moment. But I wanted to share that with you guys. Kudos to Nick and his team for getting an incredible verdict. I'm sure it's going to be challenged after the fact, and I'm sure it's going to be talked about in circles and legislatures, and probably will give rise to some tort reform legislation down there in New Mexico. That tends to be what happens when he gets these huge verdicts. So anyway, wanted to throw that out there. People have questions about that verdict or medical malpractice, feel free to leave a comment, add it in the chat. And if you have questions that aren't related to medical malpractice, feel free to answer, feel free to leave those in the chat as well. Okay, so there are a lot of misunderstandings and myths about medical malpractice. And these are things that I'm sure Nick would have gone into in great detail with his jury during voir dire. Voir dire is a fancy name for the jury selection process. That's where, at the beginning of the case, the local court system will send out a summons. A lot of you have probably received a jury summons at some point in time. They call you all into the courthouse on a scheduled date. Most people that receive a summons probably never actually get called in because the trials cancel at the last moment. And for those that do get called in, I would say the majority of jury trials are actually criminal cases. I would say not very many civil cases go to trial in most states. That's certainly true in the states I practice: Wisconsin, Minnesota, and Iowa. So one of the first myths is that medical malpractice lawsuits are easy to win. And I don't know how many times I get calls from people who had a bad experience with their doctor, hospital, could be a chiropractor, dentist, whatever, and want me to write a letter to them, basically telling them what a bad job they did and telling them what our demands are. And I think that a lot of people think that hospitals are scared of lawyers and that they quiver at the prospect of getting sued, and that when a lawyer sends them a nasty letter or a summons and complaint, that they just pull out their checkbooks and write checks. That's not how it works. At least that's never been the case in any of the states that I practice in. Um, in fact, quite the opposite is true. I haven't studied the recent statistics, but I think the vast majority of medical malpractice claims never see the light of day in terms of a lawsuit. So I think for most of us, of the calls that we get, of the emails we get, I would say well over 90% get rejected outright for one reason or another. And I'll kind of get into a little bit of those later on. Like they never even make it through the initial filtering process because there's one or more problems with the case that they don't ever get, don't get past the initial phone call with a lawyer. Those that actually do make it through that and let's say litigation ensues, a lot of those cases get dismissed or either withdrawn or dismissed during the litigation process, and a select few of them make it to trial. And of those that go to trial, I think in most states the average is, I think, well over half the time the defense, so the hospitals, doctors, the insurance companies actually win those lawsuits. It's, I think in some places the statistics are 60 to 75% of cases are won by the defense. So there's nothing easy about medical malpractice cases. And so That is a common myth that they're easy to win. I just need to go hire a lawyer, and the hospital and the insurance company will start throwing money at me. Sorry, that's not how it works. It's never been the case in my 20 years of doing this, and I don't think it's the case in any states, at least in this country. So that's myth number one. Myth number two is so if something went wrong during the surgery or treatment, that it has to be because of malpractice. And oftentimes it is a mistake, like someone actually does make a mistake. The doctor orders the wrong medication, the nurse gives the wrong drug, um, there's a typo in the prescription, things like that. Those things do happen, and those are mistakes, because they're not trying to do that during the surgery. Sometimes, let's say you're doing surgery in the on the colon or some of the other abdominal organs. People can and do get injured in those, and the wrong organ gets hit. Sometimes you get bleeding, those kinds of things. It's not on purpose, but it happens. Um, Most of the time, that doesn't rise to the level of malpractice. It may be a mistake, and it may have been an avoidable mistake, but malpractice is actually a pretty high standard. Okay. So that's a common myth, that just because something didn't go the way it was supposed to or the way the doctor said it was going to go doesn't mean it was malpractice. And even if it was because of a mistake, it doesn't mean it's malpractice. The mistake has to be sort of egregious, way beyond the standard of care, is what it takes to prove malpractice. So that's myth number two. So myth number three, and this kind of gets to my post about Nick Rowley's big judgment. So there's a common suggestion, and this is usually something that's argued in advertisements and things like that in support of tort reform. But the third myth is that medical malpractice lawsuits cause higher healthcare costs. Okay. That is statistically not true. And I think it's been demonstrated in pretty much all the studies that people do. It really doesn't have any impact on the cost of healthcare, for a lot of reasons. Number one, um, most medical malpractice cases aren't successful. They don't actually get anything out of it. Insurance companies pay for that, and even those that do are successful, or there's a settlement, is just a kind of a drop in the bucket compared to the overall cost of operating hospitals and clinics and things like that. It's a rounding error, I would say, for most large healthcare institutions. So there has been no evidence that medical malpractice lawsuits or the cost of litigating cases has any significant impact on healthcare costs, despite how hard the lobbyists and the tort reform advocates say otherwise. So myth number four is that there's the belief that a doctor will lose their medical license if they're found guilty of medical malpractice. That is universally untrue. I've never seen it happen, and in fact, it's something that we usually go over in voir dire. I was talking about voir dire earlier. Um, it is a common misconception that jurors have, that you have to deal with in voir dire, because if they believe wrongly that if they find for the plaintiff, if they find negligence, that the doctor will lose his or her license, that's a huge barrier from the outset. And so that is generally not true. And you practice medicine long enough, and most people are going to eventually face a medical malpractice case. And even if they are in the rare situation where one of those is successful, it doesn't result in loss of license probably doesn't even result in a loss of their job unless it's extremely egregious or happens over and over again. And then in those cases, I would say oftentimes there's some, let's say, behavioral health, like mental health, addiction, things like that going on that probably explains that pattern of behavior. But for the most part, simply having a medical malpractice claim brought against you, or even a successful one, isn't going to cost a doctor their license. So, myth number 5 is, and this goes along with sort of the tort reform mythology out there, that medical malpractice lawsuits are just a bunch of money hungry lawyers and plaintiffs out trying to make a quick buck. Um, that is really not the case. That it really isn't the case in my experience, any kind of personal injury litigation, things like that, but especially true in medical malpractice cases for a couple of reasons. Number one is I have found that the in almost all cases there was something that went wrong that shouldn't have happened during the course of that medical care. An unexpected outcome, a bad outcome, a very bad reaction, a mistake was made. And in a lot of cases, the reason why the people go talk to a lawyer is because their efforts to get some sort of recognition of the wrong from the hospital and the quality control people goes unheeded. A lot of it, to be honest with you, is just poor customer care. A lot of it, I think, could be avoided if they just did a better job of recognizing when people, um, you know, are harmed, and instead of trying to just kind of, you know, play games with them, which has been my experience. What usually happens, people are just frustrated, and then they call a lawyer. But second of all, and this is really the bigger reason why medical malpractice lawsuits aren't about the money, although they do involve a lot of money, is because the filtering and the vetting process is so significant. As I mentioned to you, of the calls that I get for medical malpractice, well over 90% of them I turn down, and I think that I know that is true pretty much for all lawyers and firms that handle medical malpractice cases. The vast majority of them get turned down. And those that do still go through a very slow vetting process. You have the medical records reviewed by experts, sometimes multiple experts. And there's a lot on the line because these cases are very difficult to win and very expensive to prove. Lawyers simply don't run after these cases unless they have a really strong case. And that's just, you can't bring frivolous cases. You just can't. Lawyers don't bring it because those cases will lose, and the law firm will lose tens, if not hundreds of thousands of dollars by taking frivolous cases. So that just isn't really true that they're just about the money. There is almost always merit to the claim if it ever gets to the point of a lawsuit being started. At least that's my experience. So myth number 6, notwithstanding the $412 million verdict that I talked about earlier, um, most lawsuits don't result in large payouts for a few reasons. Number one, a substantial majority of cases lose either before or at trial. So there's no payout at all in that case. That's the majority of cases. And the vast majority of cases, if you include all the cases that never get to trial. Of those that actually get to trial and actually win, you still got a huge uphill battle if you're the plaintiff and the lawyer bringing those cases to actually prove damages. A lot of states, Wisconsin, I'm trying to think of Iowa now has a soft cap, but a lot of states have have tort reform and damage caps, limits on attorney's fees, all kinds of things that uh, really diminish the value of what you can recover. Here in Wisconsin, we have a $750,000 cap on non-economic damages in medical malpractice cases. So that's things like pain, suffering, and disability. There was a very famous case, probably maybe it's been 10 years ago now, 8 to 10 years ago, where the damage cap was challenged before the Wisconsin Supreme Court. And it involved a woman who had a catastrophic injury. I think both arms and both legs were amputated as a result of it. And as you can imagine, the pain and suffering damages for that case were enormous, $15-20 million maybe. And the Supreme Court upheld the $750,000 damage cap for that poor woman and her husband and their kids. So that is one of the many reasons why the actual results tend to be, the actual results of lawsuits tend to just be very small if they win at all. And the huge verdict that Nick got down in New Mexico tend to be the extreme outliers. That is not the norm. Number 7. So I got about 5 minutes left. So I'm going to try and wrap this up. Number 7, hospitals will automatically pay money to avoid a medical malpractice lawsuit. This kind of relates back to, I think, the first one of the first couple. Hospitals are not afraid of lawsuits. I'm sure this one wasn't afraid of the lawsuit either. And rightly so, at least from their perspective, because they just win most of these cases. And if they just hire lawyers and wait out the plaintiffs and their lawyers, they have a really good chance of winning, even if the case gets to trial. And so in most states, settlements are rare. And I always tell people, if I'm looking at a medical malpractice case, I assume that if I sign up your case, I'm going to go to trial. And I don't even think about the fact that they may try and settle the case, because it just never happens. And occasionally it does, but I allow myself and my clients to be surprised by that. But you have to go into these cases with a mindset that we're going to have to sit in front of a jury and get a verdict on this 3, 4, 5 years down the road. But that's been my experience. And maybe some other states, maybe like New York, other California, I don't know, maybe it's a little different. But in any of the states that I've been involved with, it is extremely, extremely hard to get them to offer even one penny prior to a jury verdict. Here's a myth number 8. It oftentimes people believe, rightly or wrongly, that the hospital or doctor doctored or altered their medical records. And there's a few things that can happen that kind of lead to that suspicion. For example, I might see a doctor on one day, and then the doctor dictates their note. Usually they don't type out their notes. They got a little machine they talk into, or they call on the phone and they dictate, they verbally recite the record. And then there might be a few days later, maybe weeks, sometimes months later, before the doctor actually comes back and looks at the record and either makes some changes or signs off on it. And so it may show that the doctor electronically signed the record days, weeks, or months later. That doesn't mean that they changed the record, and oftentimes it doesn't. And in the days of electronic medical records, it's almost impossible, I would say almost impossible, to prove that medical records were altered, because there's going to be an electronic trail of it. And I don't see evidence of it happening very often, if at all, in any of the cases that I've been involved with. So I consider that a myth. Got 2 more. I'll go over time here a little bit. Number 9, medical malpractice lawsuits are usually frivolous. As I said before, if it gets to the point of a lawsuit, it is almost by definition, unless the person is filing it without the help of a lawyer, it is almost by definition not frivolous, because before that lawyer will actually sign their name to a document and start a lawsuit, they dang well better have had those medical records reviewed by a doctor, sometimes multiple doctors, and had those records reviewed, and have someone with the credentials say, yes, I think malpractice occurred here and that it actually caused injury to the plaintiff. So in today's day and age, it's just really not the case that lawsuits that are brought against hospitals and doctors are frivolous. Now, a lot of them are going to lose, but that's not the same thing as being frivolous. The rules and the attitudes of judges and jurors just tend to be so far weighed in favor of the hospitals, although that's changing a little bit in recent years. But by and large, people are very ready to defend hospitals and doctors, and are very skeptical of plaintiffs and their lawyers in most medical malpractice cases. Finally, number 10, and this is something that I hear a lot, that my new doctor will support us in court. So they go to one doctor or nurse or whatever, and they have a bad experience, and they go to another one, and that new doctor says, oh yeah, that other guy, he screwed it all up. I would have done it totally different, whatever. Sometimes those things are said, or at least that's the way they're interpreted in conversations with doctors. My experience has been that in most cases, in the vast majority of cases, those doctors will not actually say that if under oath. And in a lot of states, you can't compel them to anyway. Here in Wisconsin, we have something called the alt privilege, which basically says I cannot compel a doctor to testify against someone else unless they want to, even if they actually have an opinion that malpractice happened. I can't force them to do that. And so, and just as a general practical matter, doctors, unless there's something very egregious, tend to be very reluctant to testify against their colleagues, even at competing hospitals and clinics, things like that. It usually takes something very egregious, and even then, doctors and healthcare providers just tend to be very unwilling to get involved and support a claim of medical malpractice against someone else. They'll talk about the care they offered. They'll talk about what they did for them, may even offer opinions about what we call causation, like what the actual damages were, but are going to be very reluctant to talk about standard of care. That was that other person negligent. That just almost never happens, and I really have yet to see that happen in a case. So that's I consider that a myth as well. So, okay, I got through those 10. Had a little help with ChatGPT on that one to give me some ideas. Some of those I added or changed. But I hope you guys found this helpful. Like I said, my plan is to do these every day around 4:30 p.m. Central Time. Feel free to hop on and say hi and ask me about what I thought of the football game on the weekend. I probably won't be able to tell you because I don't really watch TV or sports, but I'm happy to chat about anything. But if you have any question, not sure if you need a lawyer, not sure how to find a lawyer, I'm very happy to try and answer those kinds of questions if I'm able to. Maybe I can point you to some resources or lawyers that can help you. And if it turns out that you need a lawyer and I'm able to help you, I'll be happy to set that up with you, and you can contact my office and we'll get that set up. So anyway, I saw we had a few people in the in and out of the live stream. I know it'll take a while for people to get used to this, but keep an eye out for coming days and weeks. Feel free to leave a comment after the fact if you have questions. I'll be happy to try and address them on the next live stream. And if you'd be interested in chatting on the next live stream, just subscribe to my channel, follow my Facebook page, whatever, and you'll be able to get notified of that. So anyway, all right. Well, I got that done without any major meltdown. So I appreciate everyone who was kind enough to watch this in the future. And yeah, so anyway, appreciate you watching. And until next time, everyone, have a good one.